food, clothing, and dwellings of slaves. The slave, as a chattel, is fed or famished, covered or uncovered, sheltered or unsheltered, at the discretion or convenience of his owner, like other working animals. Louisiana. Every owner shall be held to give his slaves the quantity of provisions hereinafter specified, to wit, 1 barrel of Indian corn, or the equivalent thereof in rice, beans, or other grain, and a pint of salt, and to deliver the same to the slaves, in kind, every month, and never in money, under penalty of a fine of $10 for every offense. 1 Martin's Digest, page 610, Act of July 7, 1806. 1 barrel of Indian corn, meaning a flour barrel full of Indian corn in the ear, equal to about 1½ bushels of shelled corn. The slave who shall not have on the property of his owner a lot of ground to cultivate on his own account, shall be entitled to receive from said owner 1 linen shirt and pantaloons for the summer, and a linen shirt and woolen greatcoat and pantaloons for the winter. 1 Martin's Digest, 610. Neither the quantity nor the quality of the lot of ground is specified, nor the amount of time to be allowed for tilling it. North Carolina. In case any slave or slaves, who shall not appear to have been fed and clothed, according to the intent and meaning of this act, that is to say, to have been sufficiently clothed, and to have constantly received for the preceding year an allowance of not less than a quart of corn per day, shall be convicted of stealing any corn, cattle, etc., etc., from any person not the owner of said slave or slaves. Such injured person shall and may maintain an action of trespass against the master, owner, or possessor of such slave, etc., and shall recover his or her damages. Hayward's Manual, 524 through 525. It will be observed that in neither of these legal rations of food is any mention made of meat. Georgia, the Act of 1817, as quoted in the last previous chapter on labor, provides for the punishment of owners of slaves, who by excessive whipping, by withholding proper food and sustenance, by requiring greater labor, etc., shall cruelly treat such slaves, whereby the health of such slave, etc., may be injured or impaired. Another act of December 12, 1815, is as follows. Section 1. From and after the passing of this act, it shall be the duty of the inferior courts of the several counties in this state, on receiving information, on oath, of any infirm slave or slaves in a suffering condition, from the neglect of the owner or owners of said slave or slaves, to make particular inquiries into the situation of such slave or slaves, and render such relief as they in their discretion shall think proper. Section 2. The said courts may and are hereby authorized to sue for and recover from the owner or owners of such slave or slaves the amount that may be appropriated for the relief of such slave or slaves, in any court having jurisdiction of the same, any law, usage, or custom to the contrary notwithstanding. Prince's Digest, 460. South Carolina. In case any person, etc., who shall be owner, or who shall have the care, government, or charge of any slave or slaves, shall deny, neglect, or refuse to allow such slave or slaves, under his or her charge, sufficient clothing, covering, or food, it shall and may be lawful for any person or persons, on behalf of said slave or slaves, to make complaint to the next neighboring justice in the parish where such slave or slaves live, or are usually employed, and the said justice shall summon the party against whom such complaint shall be made, and shall inquire of, hear, and determine the same. And if the said justice shall find the said complaint to be true, or that such person will not exculpate or clear himself from the charge by his or her own oath, which such person shall be at liberty to do, in all cases where positive proof is not given of the offense. Such justice shall and may make such orders upon the same, for the relief of such slave or slaves, as he in his discretion shall think fit, and shall and may set and impose a fine or penalty on any person who may offend in the premises, in any sum not exceeding £20 current money, for each offense, to be levied by warrant of distress and sale of the offender's goods, etc., etc. 2 Brevard's Digest, page 241, similar in Louisiana. 1 Martin's Digest, 638 through 640. On these enactments we remark, they embrace the legislature of only 4 states. The other slaveholding states, so far as we are informed, have never pretended to prescribe to the slave owner the kind or amount of food he must furnish his slaves. He can starve them if he pleases to do so, and there is no law to prevent it. Considering that the slave can bring no suit against his master, that he is unprovided with a protector, and that neither the slave nor any other colored person can testify against a white man, and that, in case of any interference in his behalf, whether successful or otherwise, the slave still remains entirely subject to the will of a master to whom he belongs, and who can avenge himself upon him with impunity in secret the very next day. It is quite certain that such enactments can avail little or nothing for his benefit while he remains a slave. Aside from all this, the law of North Carolina was evidently designed for the benefit, not of the slave, but of the persons from whom a hungry slave might steal a subsistence. It prescribes no relief to the slave, and no punishment to his master, but only subjects him to the payment of damages for the food his slave has eaten. Just as in the case of an unruly horse or ox that should break into a neighbor's crib, it does not even provide for the hungry slave's exemption from punishment by his master or by the magistrate for his stealing to appease hunger. There is no humanity in this law. It is a monument of the barbarity of its framers and of the slaveholders. The Georgia Act of 1817, strictly construed, imposes no punishment on a master who shall cruelly treat his slave by excessive whipping, or by withholding proper food, or by requiring greater labor, etc. All these acts of cruelty must be combined in each instance, or the statute fails to apply to the case. Even then, it is not reached, unless the health of the slave be injured or impaired. There may be cruelty by excessive whipping, by hunger, and by excessive labor. But if the subject of all this cruelty retains his health, the cruelty is not to be punished. The Georgia Act of 1815 applies only to the case of infirm slaves. Other slaves in a suffering condition from the neglect of the owner are not provided for. It requires information on oath, which no colored person can give, before a legal inquiry can be commenced. The facts must be first proved before the process can begin, and proved, too, without the testimony of the sufferer. It shall be the duty of the courts to render such relief as they think proper. From whence the supply is to be obtained, unless from the pockets of the judges, does not appear. We have copied the entire act. They are not authorized to order an execution against the delinquent owner on their judgment. Instead of this, the judges are authorized, not directed, to become suitors themselves as a court in another court, to collect of the owner the amount of the appropriation, if they can, and if not, put up with the loss as they can, cost and all. Where shall we find a parallel to this farce? The South Carolina Act must also be useful for the want of positive proof, as the slave cannot testify, in the absence of which the defendant is cleared by his own oath. We conclude, therefore, that these laws, on the whole, are no better than none. We should not anticipate from their operation any better provision for the clothing and sustenance of slaves in these 4 states than in the other slave states where no laws exist. We are not aware that there is any perceptible difference in fact, and we may extend the remark to the laws of the 4 states mentioned in the previous chapter on the subject of slave labor. The principle of slave ownership, that is to say, human chattelhood, is not impaired or infringed by them. The master has the power in his own hands. He may do what he wills with his own. Such, at every point, is the legal relation of master and slave. From the law, we now turn to the prevailing practice. From the former, we may anticipate the latter. In the work to which we have so often referred, world slavery as it is, may be found a great amount of authentic testimony of highly respectable witnesses of former and later times, for which we cannot spare room. But the substance is as follows. Hunger. Slaves in Virginia, 1820, are ill-fed. They are doomed to scarcity and hunger. Alex Smith, M.C. In 1739, they had not sufficient food to eat. They were scarcely permitted to pick up the crumbs that fell from their masters' tables. Reverend George Whitefield. They are deprived of needing subsistence. Reverend George Byrne. In 1791, they were supplied with barely enough to keep them from starving. Dr. John Edwards of Connecticut. In Georgia, their allowance is often not adequate to the support of a laboring man. Thomas Clay, Esquire, a slaveholder. In Tennessee, thousands are pressed with the gnawings of hunger. Reverend John Rankin. In North Carolina, 1826, the greater part of them go half-starved much of the time. Moses and William Swain. In Louisiana, 1835. There is a good deal of suffering from hunger, utter famishment, during a great portion of the year. A. Stone. In Mississippi, half-starved. Tobias Bowdenot. Kinds of food. The general testimony is that slaves are allowed meat only as an occasional indulgence or favor, at Christmas, etc., etc. Experiments have been made with cotton seed as a substitute in part for corn. General Wade Hampton is said to have tried the experiment till, as he himself declared with an oath, his slaves died like rotten sheep. This statement was furnished by a lady of high respectability and great moral worth to a clergyman in the West, extensively known both as a preacher and a writer. His name is with the Executive Committee of the American Anti-Slavery Society, World's American Slavery as It Is, page 29. Quantity. The quantity allowed by custom is a peck of corn a week. Thomas Clay, Esquire, Georgia, 1833. Same testimony by W.C. Gildersleeve, now of Wilkes-Barre, Pennsylvania, and Reverend Horace Moulton of Marlborough, Massachusetts, both once resident in Georgia. Maryland, same quantity, 1788. Baltimore Advertiser. Florida, a quart of corn a day, to a full task hand, with a modicum of salt. Kind masters allowed a peck of corn a week. Some masters allowed no salt. William Ladd, once a Florida slaveholder, since of Minot, Maine. North Carolina, 7 quarts of meal, or 8 quarts of small rice, for 1 week. Nehemiah Calkins, Waterford, Connecticut, resident in North Carolina 11 winters. Virginia, a pint of cornmeal and a salt herring is the allowance for 1 meal, or, in lieu of the herring, a dab of fat meat of about the same value. I have known the sour milk and clobber to be served out to the hands when there was an abundance of milk on the plantation. This is a luxury not often afforded. Reverend C.S. Renshaw, a native Virginian. John Woolman, in his journal, 1757, makes the general statement that they have in common little else allowed but one peck of Indian corn and some salt for 1 week, with a few potatoes. The potatoes they commonly raise by their labor on the first day of the week. Life of Woolman, page 74. Quality of food. There is often a defect here. Thomas Clay, Esquire, Georgia. The feed of slaves is generally of the poorest kind. Reverend Horace Moulton, in Kentucky. They live on a coarse, crude, unwholesome diet. Western Medical Reformer. Large numbers of badly fed Negroes were swept off by a prevailing epidemic. The best remedy for that horrid malady, Cachexia africana, is to feed the Negroes with nutritious food. Professor A.G. Smith of New York Medical College, once physician in Louisville, Kentucky. Number and times of meals each day. The slaves eat twice during the day. Dr. Jonathan Edwards, Connecticut, 1791. Florida. The slaves go to the field in the morning. They carry with them meal, wet with water, and at noon build a fire on the ground and bake it in the ashes. After the labors of the day are over, they take their second meal of ash cake. Philemon Bliss, Esquire, Elyria, Ohio, resident in Florida, 1834 through 1835. Mississippi, 1837. The slaves received 2 meals during the day, breakfast about 11 o'clock, the other meal after night. Eleazar Powell, now of Chippewa, Pennsylvania. North Carolina. The breakfast of the slaves was generally about 10 or 11 o'clock a.m. Nehemiah Calkins, Virginia, 2 meals a day, breakfast from 10 to 11 o'clock a.m., supper from 6 to 9 or 10 at night, as the season and crops may be. Reverend C.S. Renshaw. Meals generally taken without knife, dish, or spoon. William Leftwich, a Virginian. Georgia. The corn is ground in a hand mill by the slave after his task is done. Generally, there is but one mill on a plantation, and as but one can grind at a time. The mill is going sometimes very late at night. W.C. Gildersleeve, Esquire, a native Georgian. Similar testimony from other states. South Carolina. Only 2 meals a day are allowed to the house slaves. The first at 12 o'clock. If they eat before this time, it is by stealth. And I am sure there must be a good deal of suffering among them from hunger, particularly by children. Besides this, they are often kept from their meals by way of punishment. No table is provided for them to eat from. They know nothing of the comfort and pleasure of gathering round the social board. Each takes his plate or tin pan and holds it in the hand or on the lap. I never saw slaves seated round a table to partake of any meal. Angelina Grimke Weld. Stealing food is a crime, punished by flogging. A woman was punished for stealing 4 potatoes. P. Bliss, Esquire. Cooks, waiters, chambermaids, etc. generally get some meat every day, the remaining bits and bones of their masters' tables. Weld, page 31. The Law of Louisiana of 1806, Chapter 10, prescribing the time allotted to meals by its mention of breakfast and dinner, seems to indicate a third meal, though it is not directly mentioned. The fare of slaves is doubtless better in the slave-growing than in the slave-consuming states, and there are exceptions to the general picture we have presented. Clothing. Mr. Weld has shown by abundant and unimpeachable testimony that the clothing of slaves by day and their covering by night is not adequate either for comfort or decency, page 40, etc. Virginia, Honorable T.T. Bolden, a slaveholder, in a speech in Congress, February 16, 1835, said, he knew that many Negroes had died from exposure to weather, and added, they are clad in a flimsy fabric that will neither turn wind nor water. Maryland, the slaves, naked and starved, often fall victims to the inclemencies of the weather. George Buchanan, M.D., of Baltimore, 1791. Georgia, etc. We rode through many rice swamps, where the blacks were very numerous, working up to the middle in water, men and women nearly naked. William Savory of Philadelphia, Minister Friends Society, 1791. Tennessee, etc. In every slaveholding state, many slaves suffer extremely, both while they labor and when they sleep, for want of clothing to keep them warm. Reverend John Rankin. The South generally. Men and women have many times scarce clothes enough to hide their nakedness, and boys and girls, 10 and 12 years old, are often quite naked among their masters' children. John Woolman, 1757, Journal, etc., page 150. Both male and female go without clothing at the age of 8 or 10 years. John Parrish, Minister Society Friends, 1804. Same testimony from many others more recently. Alabama, 1819. Hardly a rag of clothing on them. Generally the bedding was a blanket. S. E. Maltby. Virginia, 2 old blankets. William Leftwich. Advertisements of fugitives every year often describe them as ragged or nearly naked. Florida. They were allowed 2 suits of clothes a year, 1 pair of trousers with a shirt or frock of Osnaburg for summer, and for winter, 1 pair of trousers and a jacket of Negro cloth, with a baize shirt and a pair of shoes. Some allowed hats, and some did not, and they were generally, I believe, allowed 1 blanket in 2 years. Garments of similar materials were allowed the women. William Ladd, late of Minot, Maine. The slaves are generally without beds or bedsteads. I have seen men and women at work in the fields, more than half naked. Testimony furnished by Reverend C. S. Renshaw from his friend. In Lower Tennessee, Mississippi, and Louisiana, clothing made of cotton bagging, no shoes. G. W. Westgate. Will of the celebrated John Randolph of Roanoke, Virginia, distinguished as a kind master. To my old and faithful servants Essex and his wife Hetty, I give and bequeath a pair of strong shoes, a suit of clothes, and a blanket each, to be paid them annually. Also an annual hat to Essex. No socks, stockings, bonnets, cloaks, handkerchiefs, or towels. No change either of outside or inner garments. And a solemn last will and testament was deemed necessary to secure to them even the articles specified. Family servants, waiters, etc., and hotel attendants must needs appear decently clad, and kept mistresses of gentlemen are often arrayed extravagantly. Superficial observers and shallow thinkers, seeing this, report the happy condition of slaves in general, having never seen the Negro quarters on the plantations. Dwellings. These generally contain but 1 apartment, and that without a floor. No partition to separate the sexes. Nothing that a northern laborer would call a bed, sometimes built by themselves of stakes and poles, and thatched with palmetto leaf, sometimes of clay, no window glass or sashes, not sufficient to keep off the inclemency of the weather, sometimes built of logs, on old plantations, sometimes of frame and clapboards. Size 8 feet by 10, or 10 by 12. and but 8 feet high, without any chimney, a hole at top to let the smoke out, generally put up, in Georgia, without a nail, ill ventilated, surrounded with filth, with neither chairs, table, nor bedstead. On the cold ground they must lie without covering, and shiver while they slumber. Such is the picture attested by competent witnesses. Wells' Slavery as It Is, page 43, etc. Treatment of the sick, the infirm, and the aged. On this topic we have not room here to enter. In Mr. Wells' work, page 44 and 45, may be found statements from the late Reverend Dr. Channing of Boston, once resident in Virginia, extracted from his work on slavery. From Miss Sarah M. Grimke, formerly of Charleston, South Carolina. From George A. Avery, merchant, Rochester, New York, once living in Virginia. From Reverend William T. Allen, once of Alabama. The late Reverend Elias Cornelius, page 161. See Edwards' Life of Reverend Elias Cornelius, page 101 through 103. And several others, all showing that great barbarity characterizes the slaveholders, generally in their ill treatment or neglect of these unfortunate beings, held dependent upon them, and defenseless as slaves. Into all the particulars which go to make up the dreadful condition of the slave, the plan and limits of the present treatise do not permit us to go. We select mainly such facts as illustrate the slave laws, and the consequent legal relation of master and slave. At every step we find it a relation identified with wretchedness and wrong. From Wheeler's Law of Slavery, it would seem that slaveholders are in the habit of refusing to pay physicians for medical attendance on their slaves, and that suits at law are the consequence, which are variously decided, the decisions of a lower court being sometimes reversed by a higher. The following points are put down by Mr. Wheeler in his marginal titles. Dunbar versus Williams. 10 John's New York Report, 249. No action lies by a physician against the master for attendance upon a slave without his knowledge, unless it be a case of extreme necessity. Wheeler, page 225. Wells versus Kennerly, 4 McCord, South Carolina Report, 123. The owner is not liable for medical attendance upon a hired slave, given at the request of the hirer. Wheeler, page 226. It is hardly to be expected that the temporary hirer of a slave would be forward to incur the expense of much medical attendance. In the case of Johnson and others versus Barrett, Judge Johnson, South Carolina, said, "If a slave be in peril in the absence of his master, the interest of the owner is most effectually subserved by rendering assistance to the slave, and in good conscience the owner is bound to make satisfaction." Wheeler, page 226. The legal rule then is to give medical aid when the interest of the owner demands it.